items for pronouncement of judgment. Item number 33, RSA 132 of 2018.
Second appeal dismissed.
Item number 34, FAO 34 of 2024.
Appeal dismissed.
Item number 35, RSA 65 of 2024.
Appeal dismissed.
May legal logic. Under special circumstances, I have come here to prayer for an unlisted motion, my lords. The trial could held that I had reached the
When do you want?
today, my lord. if
Not
possible.
today. No, sorry.
Tomorrow.
Not today. Tomorrow, Kabir? Possible?
Tomorrow.
Okay,
so
tomorrow we'll
grateful.
try.
I'm grateful.
Hmm.
I beg to mention item number 1. This case, Mr. M. Dotto is the leading counsel. He has requested me to make a mention. He is suffering from viral fever.
Okay, okay. On the appeal being made by Mr. Bhattacharya, learned counsel appearing on behalf of Mr. M. Datta, learned counsel for the petitioner, rests shall list the matter on Friday. Friday is holiday.
Then next Monday.
On 18th.
Okay.
May I please, Your Lordship? Lordship, prayer for listing of an CRPIO
When?
on Wednesday. It's an urgent matter. I will be
Motion?
executed. Motion.
Wednesday, 13th.
Okay.
Obvious.
MSc appeal নিল এটা মিস্টার লাস্ট মিলাদ 11/6/24 for hearing. So might be next week Monday or Friday.
For hearing, Lordship. For hearing
Hearing.
in the month of December.
Hearing in November, not possible. Already a lot of matters fixed.
December I'm giving it.
December 10th, December.
May I pray for listing of this IF for minor correction, my lord, in MSc appeal? Can it be on Wednesday or next? Or on 2 MSc appeals, my lord, please to list it last on 15/12/2022. Can it be listed next week, my lord, any date, my lord?
Oh, hearing?
For orders, my lord.
On 20th, 20.
Much obliged.
Wait, please, Lordship. These two matters, ISCB, Lordship, it relates to release of the amount deposited with the insurance company.
When do you want?
13th, Lordship.
13th. Okay.
May I please, my lord, I am for item number 12, my lord. This matter may be adjourned for the day.
On the appeal being made by Mr.
Yes, sir, Babu.
S.R. Barboya, learned counsel for the appellant, rests shall list the matter on
After week, my lord,
after
1 week.
1 week. After 1 week.
May I please, your lordship, I beg to mention for listing of two MSc, both are related. Last listed on 24th September. Lordship, kindly, both the matters may be listed on Thursday, 14th.
In which column?
Orders, lordship.
Orders.
Possible?
Orders, okay.
Okay.
14th.
Please, Lordship. So I'm paying for listing a MSc appeal, Lordship. It is last listed on 11/9/23, Lordship. I'm just paying for a date on next week, Lordship.
Or?
Orders, Lordship.
Okay.
Orders. On 25th.
May I please, your lordship? Your lordship, I beg to mention two RSA for listing lordship in orders column. Can it be on Wednesday, lordship?
On Wednesday. Wednesday, we're given many cases, Lordship.
And on Thursday, lordship.
One on Thursday, one on Monday. Okay. One on 14th, one on 18th.
May I please, Lordship? My lord, two CRP, my lord, for orders, my lord. Any convenient date, my lord, for orders.
Okay.
27th November.
Yes.
May I please, your lordship? It is concerned the other side. I beg to mention item number 38. I pray for adjournment for today. Lawrence English Council has gone to Bihar, his native place, for the treatment of his grandmother.
Mr. Your good name?
S.A. Bakhtiar,
S.A. Bakhtiar, learned counsel appearing on behalf of
respondent 1.
Respondent number 1. Where is your name in the cause list?
My senior counsel is there, so.
Who is your senior counsel?
NLM, on behalf of NLM.
Pardon?
On behalf of NLM.
Mr.
Respondent one.
Bakhtiar, learned counsel appearing on behalf of Mr. N. Bakhtiar,
NLM.
learned counsel for the respondent with consent from the other side, price for listening the matter.
For the appellant, so execution case is fixed today, therefore the matter was fixed and they were asked to submit their reply in the stay petition, stay matter. Appeal already admitted. So my humble prayer is that the execution matter may be stayed and they may be allowed to file their objection to it.
Lordship,
Otherwise, they may pursue the execution matter and they are taking time here.
No, we'll fix a short date.
a date may be fixed.
On that day, we'll consider short date.
On 20,
But, Lordship, it will be difficult for us, after 28 or 29 November,
28,
28,
28.
28. Wait.
Till then, the execution matter will stay.
Lordship.
On that day, we'll consider.
On that
They
day,
also do have the objection
on
for
that day,
stay,
it can be
only they have
considered,
to
Lordship,
import some security amount.
it can be had on that day, Lordship, because we, on the last day, we have prayed.
No, 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 on that day, we'll consider. Otherwise, we'll call the matter. If you want to pursue the matter today, we'll hear you.
I'm ready.
Ready?
But they have to file their objection, they will have to file their objection.
Lordship,
Let them file objection on next date. We will consider your pair for stay. Kabir, short date,
Short date, then 21st,
21st.
21st,
24,
short date, 21st.
21st will be difficult for us, and this council will not be here, so after any date of 21st,
25th.
25th.
Yes.
Me, please, my lord. My lord, I beg to mention a regular second appeal for listing. Otherwise, the appeal has been admitted, but the application for stay has not been heard as of yet.
Hmm.
Objections have also been filed by the other side.
Is there any urgency?
My lord, the urgency is direction for issuance of writ has been passed on 5th of November. Hence, I pray that at least the prayer for stay of the execution proceeding may be heard on Thursday.
Thursday,
Possible?
on 14th.
Oh.
Okay.
IA may be heard, my lord, the
Okay.
interlocutory application.
May I please, your lordship. Lordship, I beg for listing a RSA matter, lordship.
When?
Lordship, any date, lordship, in order column, lordship.
Orders column, on
Okay.
22nd November.
My lord, there is another prayer in a revision petition. An amendment application was filed. Any day your lordship pleases, lordship may fix the matter. That has not come up.
29th,
Very well, my lord. Deeply obliged.
May it please, your lordship. Lordship, we have filed an IA. Can you please list it on Wednesday?
IA in which case?
IA for condemnation.
Delay.
Wednesday, 13th.
So I would like to mention item number 31, Lordship. This matter, Council Mr. B. Kaushik was supposed to appear, Lordship, but he's out of station. today.
Item number 31.
Lordship,
You are for the respondent or petitioner?
petition.
Your good name?
W. Rahman, Lordship, on behalf of B. Kaushik.
Mr. W. Rahman. You informed the other side?
Yes, Lord.
When?
Actually, yesterday night only we have informed, and today morning also we have informed them.
Learned counsel appearing on behalf of Mr. B. Kaushik, learned counsel for the petitioner with consent from the other side, possible listing the matter on
On Wednesday, Lordship, this week only.
On Wednesday, already so many cases. Lordship. On next Wednesday, 20,
Then, Lordship, next Thursday, Lordship.
Thursday.
14th. Hearing day, Lord. Okay, 14th.
Okay.
Hello.
May I please, Your Lordship?
Mm.
Your Lordship, listing of an MSc appeal for admission on the next Monday, Your Lordship. Highly obliged.
18th.
Please, your lordship, I beg to mention for listing lordship. Matter is RSA matter. I beg to mention for order column lordship.
When?
Orders.
Any date lordship.
Next
On-
week? Kabir.
On 22nd November.
Or lordship.
Items from daily list for motion, item number 2.
Yes, please, Your Lordship.
Hmm.
Well, the matter is against an order passed by the learned trial court. So what has happened in the case, my lord, there was a suit filed by me seeking amongst other the easementary rights over a plot of land which belongs to the respondents. my plot of land was identified as Schedule A, and the plot over which I am seeking easementary right was identified as Schedule B. Initially, there was an order of status quo, but that was set aside on appeal, against which a revision was preferred before this honorable court. And this honorable court had passed a judgment directing the learned trial court inter alia to put a commission for examining the status of the case, whether my right of egress and ingress to my land is anyway affected or not. Your lordship will kindly see that order of the honorable court, this honorable court, at page 75.
Mm.
Now, in terms of that order of this honorable court, the learned trial court placed a commission.
Mm.
Now, the commission report came, and in the commission report, it was identified that the Schedule A land, which belongs to me, the egress and egress to Schedule A land is obstructed because of the construction carried out by the respondents on the Schedule B land. Now, while considering this aspect of the matter, the learned trial court has passed the impugned order, and erroneously, my lord, in the order, last part of the order, last paragraph of the order, the trial court has mentioned about the Schedule A land, identifying it to be as the disputed land, whereas the Schedule A land is not the subject matter of dispute, it is the Schedule B land over which the dispute is arising. I'll just draw your lordship's attention to the last paragraph of the order. Your lordship will kindly come to page 107. Paragraph 26.
Yes.
Further, in light of the findings of the commission report, the court hereby directs both the parties to maintain status quo specifically with respect to the structures identified in the report on the disputed land within bracket Schedule A. This is the error. Schedule A is the land belonging to me, and there is no dispute with regard to Schedule A. The suit has been filed claiming right of egress and ingress over a park which is situated on Schedule B, and that is the admitted position. So this and the existing ingress and egress of the plaintiff's land. No further construction, demolition, or modification of any structures on the identified portion of the disputed property is permitted.
Where is the plane?
Paragraph 2 of the at page 4, paragraph 2, your lordship will kindly see. Petitioner as the plaintiff. Am I with your lordship?
Yes.
Petitioner as the plaintiff filed title suit number so and so in the court of learned Munsif Darang, which was subsequently transferred to the learned court of so and so, and same title suit was.
My question is, have you enclosed the copy of the plaint along with this petition?
No, the copy of the plaint is not.
Produce it. We'll examine.
But the facts are admitted, my lord. I can show it from the judgment of the previous judgment of this honorable court also, that it is the Schedule A land which belongs to me.
You produce the because you were praying for staying that order.
If your lordship permits me, I can produce the. Of course, it is not part of the record, but the copy we have.
You produce it by way of an affidavit.
In that case, your lordship may kindly grant us some time.
Okay, day after tomorrow, file an additional affidavit as prayed for by Mr.
My lord, I am S. Datta.
S. Datta, learned counsel.
Well,
For
I
the
am
petition.
I am senior counsel assisted by him.
Okay, assisted by Mr.
DA
Learned counsel for the petitioner. Recess is the matter day after tomorrow. So as to enable Mr. Datta to file an additional affidavit bringing on record the plaint of the title suit number. What was the number of the title suit?
Title suit number 137, renumbered as 7 of 2003. No, sorry, 2013, 7 of 2013.
Okay.
Obliged.
Item number 3, matters for admission.
Your lordship, it may be taken after some time. Mr. Senior Advocate is on late at 2 p.m.
Who is your senior advocate?
BD das. Senior, sir.
Lordship, in this matter, MS4 is supposed to appearing, but she is unwell. That's why kindly fix the matter after 1 minute.
Let Mr. Das come. We will consider your pair.
Item number 4. Item number 4.
Please, your lordship. My lord, this revision interlocutory application has been filed against the order passed by the learned Munsif of Sonitpur, my lord. My lord, I was directed to submit the copy of the plaint and written statement by the order dated 12th day of June 2024. Because at the time of filing the revision petition, that was not accompanied by the copy of the plaint, as those the certified copy was not available with me. So subsequently, I filed and it has come. The plaint is required to be, I made a statement at the time of hearing, I will submit it. But anyway, as per the order of this court, I have submitted because.
When
the
you
event-
have submitted?
My lord,
When you have submitted?
affidavit, as per order of the court, my lord, there was an order of the court that the copy of the pleadings must be furnished. So in compliance with that order, I filed it, my lord.
When?
That order, it was filed on 24th day of July 2024. Order was passed on 12th day of June 2024. So the plaint is before a lordship, the pleadings in fact are. I was aggrieved by the order passed by the learned Munsif, refusing my prayer for sending both cell deeds under order 26 rule 10A for scientific investigation. The ground of rejection of sending was only at page 36. Your lordship may be pleased to look at line number 2, my lord, page 36, annexure 6. Your lordship has found, you know. It is pertinent to note that the plaintiff nowhere in his plaint stated regarding another land executed through registered cell deed number 299 of 97 dated 10/3/97. However, the plaintiff has stated in his plaint regarding another land as measuring 2 bighas, 2 kathas and 10 lesas, but nowhere has he admitted the execution of cell deed number 299 of 97. In fact, the plaintiff has totally denied the execution of impugned cell deed by late Prithviraj Vishwakarma. This impugned cell deed is not relevant for adjudication of the matter in dispute in the instant suit, as the dispute is with respect to cell deed number 8 of 1998. The facts of the case in brief is that the petitioner was sold land at measuring 2 bighas, 2 kathas, 10 lesas in the year 1997. And subsequently in the year 1998, under the same doubt, from the same patta, another 1 bigha, 2 kathas was sold to the petitioner defendant by the predecessor in interest of the plaintiff opposite party. They denied that the subsequent sale was made by their predecessor, and they alleged that that was a fraudulent, void registration deed, my lord, and they sought for cancellation. So the application was filed for sending both the sale deeds because in the plaint, though they have not stated the number of the sale deed, but they have admitted that there was a sale of 2 bighas, 2 kathas, 10 lesas land to the defendant. My lord, my humble submission before lordship, as per section 17 of the Registration Act, my lord, what sale can take place? 2 bighas, 2 kathas, 10 lesas of land. Although it was not mentioned in so many terms, but the sale had been admitted by the opposite party. So my humble submission before lordship that a learned trial court failed to look into that aspect of the matter and pass the interim order holding that they nowhere have stated anything regarding another deed. But at the same time, the court has come to a finding that they have admitted that there was a sale of 2 bighas, 2 kathas, 10 lesas to me. So, as an abandoned portion, and prudence also needs that the scientific investigation under Order 26, Rule 10A is necessary and expedient. The order says itself, when any question arising in a suit involves any scientific investigation which cannot, in the opinion of the court, be conveniently conducted before the court may, if it thinks fit necessary or expedient in the interest of justice, so to do, issue a permission to such person as it thinks fit, directing him to inquire into such question and report thereon to the court. So, my lord, this prayer for sending for the deeds for scientific investigation should have been allowed by the court below, and on.
So earlier similar pair was rejected.
Yes, I have annexed, my lord, I have annexed it, but a liberty was given that if any dispute arises in future, then we had the opportunity to raise that. Because in evidence, the plaintiff, number one, she has denied that she has no knowledge that such execution, such sale had taken place. So that this is also under challenge. And the finding of the court, even if it is assumed that earlier there was a petition and that was rejected, although with a liberty, but the learned court below, while passing the interim order, court has not said anything regarding that. Court has said the plaintiff is silent regarding the sale deed which was executed in respect of 2 bighas, 2 kathas, 10 lesas of land. But it is implied, my lord. The implication is there, Section 17 of the Registration Act, my lord. Without
No,
registration.
maybe if you have not mentioned in the plaint,
Yes, my lord.
if you have not mentioned about that sale deed in your plaint, how can subsequently you praise that it may be sent to the FSL for comparison?
And the defendant, my lord, plaintiff court's finding is that in the plaint, the plaintiff has not said anything regarding the registration deed. In my written statement under paragraph 8, I have clearly stated, my lord, paragraph 8
That page number?
of the written statement. Yes, at page 3, my lord, the interim number, the paragraph 3. That it is
Paragraph
a fact.
number.
Paragraph 8, my lord, at page 3 of my written statement, that it is a fact that the plot of land measuring 2 bighas, 2 kathas, 10 lesas, covered by DAG number 293 of periodic Patta number 47 of village Kochuville, Moja, Goroimari, had been sold by Prithviraj Vishwakarma by executing a registered sale deed being number 299 for year 1997, executed on 18/3/97 in favor of the defendant as stated in paragraph 3 of the plaint. The said Prithviraj Vishwakarma by executing another registered sale deed being number 8 for the year 1998, executed on 5/1/1998, another plot of land measuring 1 bigha 2 kathas covered by DAG number 193 of periodic Patta number, same Patta, same DAG, of 47 of village Kochuville, Moja, Goroimari was sold and transferred to the defendant, and the possession thereof had also delivered to the defendant, and the defendant took the possession thereof. That be it mentioned that the aforesaid plot of land measuring 1 bigha 2 kathas lies on the eastern boundary of the plot of land measuring 2 acres, 2 quarters, 10 acres of the defendant purchased earlier. And both the plots of land have been in continuous possession with year to year paddy cultivation in 1998. It's a contiguous, my lord. Both plots are contiguous, but only ground that was considered by the court below, that it was in the plain disregarding cell deed number 227 of the year 1997, there was complete silence. My lord, it is not, my humble submission, it is not required. By implication, it is understood that when sale took place, as per section 17 of the Registration Act, no sale can take place, my lord. They have admitted that their father had sold the land to the defendant. Same dark, same patta, the quantity of land, everything is correct, my lord. Record says that. So, my lord, for the sake of prudence, my lord, is for sending both the sale deeds for scientific investigation should have been allowed, my lord.
Yes.
At the outset, my lord, only submit that, my lord, this petition is not maintainable in view of the order dated 28/5/2015, my lord. And that order has not been challenged, my lord.
Which one? Which order?
They have annexed it at Annexure 1, my lord. Page
Okay.
number 21, my lord.
Page number 21.
21, my lord. Lord, may come to the next page, my lord. The findings of the court, second paragraph. Hence, the case record shows that the dispute is regarding execution of sale deed number 8 of 1998, by which defendant claimed to have purchased the suit land, plaintiff sought cancellation thereof. Admittedly, the sale deed number 299 of 1997 relates to the another plot of land. Hence, sale deed number 299 of 1997 is not relevant in adjudication of the matter in dispute. Hence, no purpose will be served by sending the sale deed number so and so for expert opinion. In the plain, though the plaintiff has stated that 2 bigha, 2 katha, 10 acres of land was sold by Prithviraj Vishwakarma to the defendant, but nowhere in the plaintiff had admitted the execution of sale deed number 299 of 1997 was executed by late Prithviraj Vishwakarma. In the written objection, filed against this petition, also the plaintiff has denied the execution of sale deed number so and so by late Prithviraj Vishwakarma. And the signature, if any, put in the sale deed number so and so is not the admitted signature of late Prithviraj Vishwakarma, on the basis of which the signature of late Prithviraj Vishwakarma put in sale deed number 8 of 1998 may be compared. And decision may be arrived at to whether the late Prithviraj Vishwakarma executed the sale deed number 8 of 1998. This is the findings of the court, my lord. This has never been challenged, my lord. Court has simply said, my lord, needless to say that if the dispute arises, dispute is already there, my lord, in respect of the suit land, then the defendant at appropriate stage may pay for expert opinion. But, my lord, next part is important. But in the present case, as the signature, if any, put in the sale deed number so and so is not admitted signature of late Prithviraj Vishwakarma, and the sale deed number 299 of 97 cannot be sent for comparison with the signature of Prithviraj Vishwakarma put in sale deed number 8 of 1998. In view of this order, my lord, this petition is not maintainable now, my lord, after 8 years, my lord, because this is a finality and this order has never been challenged, my lord. And moreover, when, my lord, sale deed is not admitted, my lord, when that can be sent for comparison, how that can be sent for comparison for expert opinion, my lord?
There is no admitted signature.
No, my lord, we have not admitted, my lord. There has to be an admitted signature in order to get it compared by an expert, my lord. But we have never admitted, my lord. This has been attained finally to the earlier order, my lord. This order has never been challenged, my lord.
Where liberty is granted here?
Liberty is granted, but the court has given its findings, my lord.
But when the evidence was in progress of the defendant, an application was filed, that part was over, my lord.
No, you show me in which part of the order the court has granted liberty to you.
The last
Paragraph, my lord.
Needless to say, my lord, the paragraph. Needless to say, if the dispute arises regarding execution of the sale deed number so and so in respect of the suit land, then the defendant at appropriate stage may pay for expert opinion.
Acha. So it has been kept open.
It's open, but the court has held, my lord, thereafter that, since there is no admitted signature, my lord, that cannot be, those
Sent.
cannot be sent for expert opinion for comparison. There has to be an admitted signature, my lord, of this plaintiff, my lord. Plaintiff's father, my lord. There has to be an admitted signature. When there is no admitted signature, my lord, how that can be sent for expert opinion, my lord? What purpose that will serve, my lord?
Yes, what is your answer?
My answer is that I have annexed the order which my learned friend has challenged, that order was not challenged before the court below. But in fact, when there was a liberty in case of dispute, my lord, in the plain.
That's all
there-
right. The
in the plain
liberty was
there-
granted to you, but where is the admitted signature of the person concerned?
No, my lord, what has happened in the plain, they have stated that there was a sale, but in the evidence, in cross, he denied, মোৰ দেউতা পৃথ্বীৰাজ বিশ্বকৰ্মাই কোনো মাটিয়ে বিবাদী বিক্ৰী কৰা নাছিল। So the sale which was admitted in the plain, my lord, the former sale of 2 acres, 2 quarters, 10 lesses, in cross, there was a complete denial. মোৰ দেউতাই পৃথ্বীৰাজ বিশ্বকৰ্মাই কোনো মাটিয়ে বিবাদী বিক্ৰী কৰা নাছিল। So a dispute was raised, and I have utilized the liberty, my lord, when my evidence was in progress, my lord. And others also,
No, that's all right. There is a dispute, but to compare with the signature, where is the admitted signature of the person concerned?
admitted signature is in the former sale deed, my lord, because when the sale took place, the petitioner in interest of the plaintiff put his signature before the register, my lord. And when the subsequent sale deed, which is under challenge, alleged to be forced, and for cancellation, they are praying for cancellation. My prayer was that both the sale deeds should go to the for scientific investigation to arrive at a correct finding, my lord. Law prudence also says necessary and expedient. Order 26 is very clear, because law prudence also and equity. So there is nothing wrong if both the sale deeds are sent for scientific investigation, because I have been stating in my written statement that by sale deed number 227, the plot of land was 2 acres, 2 quarters, 10 lesses was sold to me by the plaintiff.
Okay.
Predecessor. And that has been admitted in the plaint, my lord. Only thing, the courts, while passing the impugn order, that in the plaint, they have not stated the number of the sale deed. My lord, it is not required. Order Rule 17 of the Registration Act, it is compulsory, my lord. No sale can take place without registration. Registered deed is there, and I have submitted that my registered sale deed 227 of 1997, the plot of land which was sold earlier by their petition has been admitted by Indiplain, and subsequently they have denied that the second sale was not taken place. I have forced it. So my prayer that both the sale deeds, if a scientific investigation is made, it will be expedient, and it will assist the learned court also to come at the correct finding, my lord. So my humble submission.
Okay, we'll pass the order. Next item.
Item number 5,
But
item number 5.
Please, your lordship. Lordship, the affidavit has to be filed by the higher education department. So lordship, kindly fix a date.
Who is for higher education? Where is your affidavit?
Lordship, I have some instruction of 2023, Lordship. I need some time to obtain the up-to-date instruction, Lordship. In the meantime, Lordship, I will get the up-to-date instruction and file my affidavit, Lordship.
Heard, Mr.
R. Guhai, appearing on behalf of M. Sharma.
R. Duhai, learned counsel, appearing on behalf of Mr. R. Sharma, learned counsel for the petitioner, and also heard Mr.
The Upamanya. For respondent number
The
one and
Upamanu learned counsel for the respondent number
1 and 2, Lordship.
1 and 2. Mr. Upamanu Samanstep. He had obtained instruction in the year 2023. And he may be permitted to obtain, no, he may be granted some time to obtain up-to-date instruction in this regard. And thereafter he will file affidavit in opposition. There is accordingly allowed, list the matter on when,
After 2 weeks, Lordship.
after 2 weeks.
Very okay.
Sub number 6.
May I please? Lordship, kindly matter may take up after 10 days, Lordship. We have filed our affidavit. There is some difficulty in the Lordship on the part of my senior.
On the part of your,
Senior, Lordship.
who is your senior?
B. Goswami.
Lord, I won't object to it, but I have some urgency in the sense, my lord. The career of the petitioner is coming to an end, only 4 years left, my lord.
Hmm.
And willfully they have held up the promotions. That's why, my lord, the date may be fixed, my lord.
Okay. On the pair being made by Mr.
P. Kakoti, Lordship.
P.
for
Kakoti,
respondent number
learned counsel appearing on behalf of Mr.
B. Goswami.
B. Goswami, learned counsel for the standing counsel for the respondent number,
4 and 5, Lordship.
respondent number 4 and 5. Receives and list the matter on
29th.
29.
29. Okay. 29.
March of it.
Oblige.
Sub number 7.
May it please your Lordship. Lordship, this is an MSC appeal, Lordship, filed by the insurance company. Lordship, here, Lordship, the ground is that the deceased person was a government service, Lordship. And there is a clear evidence from the official witness examined by the claimant that the family members are entitled to receive the benefit under the Compassionate Family Pension Scheme 2017, Lordship. So under that scheme, the family person should receive 100% of the salary received by the deceased at the time of his death, Lordship. So in that event, Lordship, there is no loss of financial dependency. So this is the ground we have approached, Lordship.
Heard Mr. T. Coletta, learned counsel for the appellant. This appeal under section 173 of the MB Act is directed against the judgment and award dated 38/7/2024 passed by the learned member MSCT number 2 Kamrup M. Guwahati in MSC case number 1220 of 2019. It is to be noted here that by impugned judgment and award dated so and so, the learned tribunal has directed the appellant herein to pay a sum of rupees
Lordship, it is 5208, page number 34.
52 lakhs 8,216.97 rupees. And further directed that the said amount shall carry interest at the rate of 9% per annum from the date of filing of the claim petition. Peruse the memo of appeal and the grounds mentioned therein. Let notice be issued to the respondents returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. Justice shall call for the record from the learned tribunal. List the matter after 4 weeks. I'll let notice go. This is the
Lordship, considering the ground state for Lordship and the age of the deceased 52, 20% may be allowed to be deposited, Lordship, because I'm relying on the judgment of Shashi Sharma, wherein the concept of future prospect is there. Future prospect, they are entitled, Lordship. So future prospect is equal to 20% of the awarded amount, Lordship. So 20% we are able to deposit, Lordship.
you deposit 50%, thereafter that will be deducted. Or Mr. P. Colita, learned counsel for the appellant. This interlocutory application under Order 41, Rule 5 of the Code of Civil Procedure is referred by the applicant for staying operation of the impugned judgment and order dated 38/7/2024, passed by the learned member, MSCT number 2, Kamrup and Guwahati, in MSC case number 1220 of 2019. It is to be noted here that by the impugned judgment and order dated so the learned tribunal has directed the applicant herein to deposit, not to pay a sum of rupees
5208.
being the compensation to the respondent. No, to the respondent opposite parties. The connected appeal has already been admitted and the record has also been called for. And considering the facts and circumstances on the record, this interlocutory application allowed, stands allowed subject to payment of rupees 50, payment of 50% of the awarded amount before the registry of this court within a period of 2 weeks,
Lordship, it's a big amount, Lordship, 4 weeks at least, Lordship, 4 weeks.
3 weeks.
Lordship, may I pray for giving an observation that until further the debt award may not be withdrawn, Lordship.
No. That will frustrate the object of the benevolent provision of the section
Right.
166.
That's all.
Item number 8.
May I please, Your Lordship? Your Lordship, this appeal has been referred by the claimant for enhancement as well as modification of the award dated 18/8/2024. Your Lordship.
What is the ground?
If my claim is that, my claim was that my deceased husband was a pedestrian and he was hit by a truck. Finding of the court is that relying on evidence that my husband was traveling in that particular truck, whereas there was specific evidence on record to show that my husband was a pedestrian. And not even a single question was put to my eyewitness, to one eyewitness or to the claimant regarding my status as whether as a pedestrian or occupant of the truck. Relying on evidence, hearsay evidence, not eyewitness. This is one of the grounds. There are other grounds for enhancement also, Your Lordship.
Okay, heard Mr. D. Mandal, learned counsel for the appellant. This appeal under section 173 MB Act is directed against the judgment and award dated 8/8/2024, passed by the learned member, MSCT Golpara, in MSC case number 126 of 2017. It is to be noted here that by the impugned order dated, impugned judgment and award dated so the learned tribunal has directed the respondent.
Owner of the
Number
vehicle,
one.
respondent number 2. Owner of the vehicle was directed to make the payment. Insurance company was exonerated.
Why?
Because I was shown to be a gratuitous passenger. Even in case, when I have, my deceased husband was a gratuitous passenger, then also the theory of pain recovery will come. Even the court also ignored that aspect of it.
Directed the respondent number 2, Ranjan Chandra Sarkar, who happens to be the owner of the vehicle. Owner of the vehicle to pay is sum of rupees. Where it is mentioned?
Your Lordship, there are 3 analogous cases.
Page number 28.
126 case number.
What was the amount?
Amount I am
You apprise the court later on.
Yeah.
You go to the record. কি বললো?
Apply হলো।
কই দেবো পিছনে ভুল করে দেবো, insert করে। Peruse the memo of appeal and the grounds mentioned therein. Let notice be issued to the respondents returnable in 4 weeks that be taken by registered post and also by usual process within a week from today. Registrar shall call for the record from the learned tribunal to admit কথাটা লিখিবা আগতে। List the matter after 4 weeks.
Item 9.
It is a lordship.
Hmm.
Also, there is a small numerical correction to be made in the memo of bill, so it may come next week.
Okay. Mr. Argusami, learned counsel for the appellant, submits that he may be granted some time to make necessary correction in the memo of appeal. Here is accordingly allowed. Recess shall list the matter on next Monday.
It is 14,75,200.
You give it to court master.
Item
Okay.
10.
May I please,
Yes.
lordship, in the last occasion, my lord, the department has time to file the affidavit, my lord. Till they not file it, till the third date, my lord. Third time we done about the situation.
Yes, madam, why affidavit could not be filed?
Lordship, we need some more time, your lordship.
Why?
We have received a.
Okay, we will grant you time, but you have to pay cost.
Lordship, on the next day, if we didn't file, not today, your lordship.
Pardon me, sir. Hazarika.
Yes, sir.
Yes, Hazarika, learned counsel for the petitioner and madam
It's
Uh,
Terampi, lordship.
is Terampe, learned. Standing counsel for respondent number
All respondents, your lordship.
for the respondents. Ms. Terampe submits that he may be granted, she may be granted 1 week time to file affidavit in opposition. Here is allowed, list the matter on fixed date. On next date. In the event of failing to file affidavit in opposition, the court will consider imposing cost upon the respondents.
30th November.
I'm deeply aware.
11.
The matters come up under order 41 manner, for three of the operations of the impugn judgment manner. Now she will find the impugn.
It was admitted earlier.
No.
So there is concurrent finding of the learned courts below.
Yes, ma'am.
What is the substantial question of law here?
Official question of law, my lord, is that, my lord, the property that devolves in the suit, my lord, is a joint Hindu family property, and the learned, both the learned courts below are in law in saying that this is not the personal property, this is the property of the respondent, my lord. What has happened in this case, my lord? Father of the, both are brothers, my lord. There are altogether 3 brothers and 1 sister, and he has filed a suit for right title and interest, and he has not made party to both the brothers and sisters. Number 1. Number 2 is that, my lord, there is a settled position of law. Apex Court has held that, my lord.
You come to your memo of appeal. Where is the substantial question of law in the memo of appeal?
In this case, I am being engaged, my lord. This one. Yeah, my lord, page 12, my lord.
Page 12.
Yes, my lord.
Whether this page number 12 is part of your memo of appeal?
Yes, my lord.
Yes.
I'm not sure. Because someone else has told me.
You go through the subsection 3 to section 100 CPC.
Kindly for a moment, I'm bringing it up. Thank you. Okay, my lord. Last section, 102, my lord.
Subsection 3 to section 100.
In an appeal under this section, the memorandum of appeal shall precisely state the substantial question of law.
Now you come to page number 12.
Yes, my lord. It is not there.
Can it be said that you have complied with subsection 3 to section 100?
Time may be allowed, I'll correct you.
Mr. Bakshi, learned counsel for the appellant, price for granting him time so as to enable him to file amended host title. No, so as to enable him to incorporate the substantial question of law in the memo of appeal. That is accordingly allowed. Recessal is the matter after 1 week.
Item 13. My lord, the earlier occasion, my lord, your lordship was not satisfied while incorporating the substantial question of law. my lord. So that's why your lordship passed an order on 9/9/2024, my lord. And in pursuing,
Now you have filed a corrected memo of appeal.
my lord, I have
You have.
lordship.
You have filed.
Marked as, my lord, flag A, my lord. Substantial question of law, my lord. Whether the impugned judgment and decree passed by the learned courts below, ignoring the pleadings in the plaint filed in the suit vis-a-vis the sale deed dated 2024, 2004, that is exhibit 4 in the case record, have resulted into perversity and consequent failure of justice. My lord, what happened, my lord? I want to take your lordship, page 51, my lord. Reading 3 lines. Reading 3 lines, my lord. Upon which, my lord, I have prayed for declaring my right title interest over schedule land 3, my lord. Schedule land 3, my lord, here is 1 kata 8 chota, my lord. My learned court below and entirely, my lord, dismissed my suit, my lord. Whereas, my lord, if your lordship, can you peruse, my lord, page 12, my lord. Point for determination, my lord, at page 10. First point, my lord. Got at page 10 below, my lord. Point for determination 1, Roman 1. Whether the plaintiff has right title and interest over the suit land described in schedule 3 of the plaint, and if so, as to whether the plaintiff is entitled to any relief in respect of the suit land as paid for in the suit. So under these circumstances, my lord, at page 12, my lord, below, my lord, who produced the original registered cell deed number 915 dated 23/2004 from the office of the sub-registrar Kachar, and deposed that exhibit 4 is the certified copy of the said original cell deed. Thus, the plaintiff has been able to prove the suit that he was the owner of the above mentioned land. So, my lord, here the plaintiff has proved that he is the owner of the suit land, as mentioned in Schedule 3. He has successfully proved, my lord. So, my substantial question of law, my lord, in this regard, my lord, that has been ignored by the learned court below.
Learned First Appellate Court.
This is a concurrent finding of fact, my lord. What the court, my lord, learned Munship and the learned appellate court also, my lord. And so far as the, my lord, second substantial question of law, my lord, that whether the impugned judgment and decree passed by the learned appellate court below, holding that the plaintiff has been able to prove that the plaintiff was the owner of the suit land purchased by the plaintiff by cell deed number 915, dated so exhibit 4. And it is apparent from the cell deed that the plaintiff purchased 4 kata 8 chatak in the suit tag 442 by the said cell deed, and thereafter disputing the suit filed by the plaintiff in its entirety are sustainable in law. And third, my lord, substantial question of law, in this suit, my lord, the defendant did not file their written statement in the suit, and
Maybe, but you
I-
have to
I-
stand on your own footing.
lordship, I shall have to prove my own case. So, my lord, for adducing additional evidence also, I have filed an application before the learned court below. That also will ignored, my lord. That is pending in the appellate court below. Ignoring the, my lord, order 8, rule 10, and order 41, rule 27 of the Code of Civil Procedure.
Okay, only on the point number 1, we will admit the appeal. Heard, mister?
See you, Mr. Malik.
P.U. Losker, Learned Counsel for the appellant. This appeal under section 100 of the CPC is directed against the impugned judgment and decree.
Six 5/2024.
Passed by the learned additional district judge, within Brigade FTC Kasar, dated 6/5/2024, in title appeal number 4 of 2019. It is to be noted here that by the impugned judgment and decree dated so the learned additional district judge FTC Kasar, within bracket herein after First Appellate Court, has dismissed the appeal and thereby affirmed the judgment and decree dated 8/4/2019 passed by the learned civil judge number 1 Kasar Silsor in title suit number 113 of 2016. Where is the memo of appeal and the grounds mentioned therein? This second appeal is admitted on the following substantial question of law. Whether the impugned judgments and decrees passed by the learned civil judge number 1 Kasar Silsor in title suit number 113 of 2016 and the impugned judgment and decree dated 6/5/2024 passed by the learned First Appellate Court in the title appeal number 4 of 2019. First, ignoring the pleadings in the plaint. And the sale date dated 28/3/2024, number 915, which in bracket Exhibit 4, have resulted in perversity and consequent failure of justice. Let notice be issued to the respondent, returnable in 4 weeks, is to be taken by registered post with AD and also by usual process. Within a week from today, registry shall call for the records from the learned courts below. List the matter after 4 weeks.
Your Lordship, I am waiting for respondent number 1 to 4, Your Lordship.
Ms. K. Fukun, learned counsel for the respondent number.
1, 2, 3,
Learned
and 4.
standing counsel for the respondent number 1, 2, 3, 4.
Yes. A copy may be provided, including amended petition.
Since Ms. K. Fukun, learned counsel, standing counsel for the respondent number so and so entered appearance and received notice, no formal notice is required to be issued. However, extra requisite copy of the petition may be furnished to her during the course of the day, including the amended memo of appeal.
One private respondent is also there, you know. Respondent number 3.
So notice will go.
Fine.
Whether any execution case has been filed?
No, ma'am.
No.
No.
So we will, in the IA also, we will issue notice.
In order, maybe.
No. Not in a routine manner.
Then, my lord, the status quo may be maintained.
No, let notice go at this instance.
Well,
This interlocutory heard Mr. P.U. Loskar, learned counsel for the applicant, and Ms. K. Fukun, learned standing counsel for the respondent number so and so. This interlocutory application under order 13(9) Rule 1 and 2 read with Section 151 of the Code of Civil Procedure is preferred by the applicants for granting temporary injunction restraining the opposite parties stroke respondents from disturbing the position of the petitioner stroke appellant over the suit land described in the plaint. Let notice be issued to the respondent, returnable in 4 weeks. Step be taken by registered post with AD and also by usual process. Since Ms. Fukun entered appearance on behalf of respondent stroke opposite party number so and so, no formal notice is required to be issued. However, a copy of the petition will be furnished to her during the course of the day. Notice to the other respondents be issued by registered post with AD and also by usual process. List after 4 weeks.
only one small prayer, my lord, before your lordship. In the memo of appeal, my lord, in the main appeal, my lord, the appellant may raise any other substantial question of law, my lord.
Okay. Yes, after this substantial question on law, incorporate one line. The court may also consider framing of any other substantial question of law if found necessary at the time of hearing after giving notice to both the parties.
I'll oblige. Item 14.
My please, Lord. Also, concurrent findings are there is apparent perversity. Your Honor, firstly, Your Honor, kindly bear in my proper substantial question of law at page 8. First, regarding non-consideration of clear admission, and secondly, Honor, non-consideration of principle of section 25 of limitation act, and third, the mandate of under order 41 rule 31. If Your Honor kindly peruse my plan first, Plan start from page 11, Lordship.
You amend your
Yes, Lord.
memo of appeal
Yes, yes.
incorporating the substantial
sir.
question of law. Third, Mr. Your good name?
Orally.
Or only? No, already we have directed you by the order dated 11/9/2024.
That has been complied, Lordship.
When?
I forgot the date. If your Lordship kindly peruse page 8. Substantial question of law earlier,
Page 8.
Lordship. Eight and 9.
No, is it the amended memo of appeal?
Yes, Lord.
No.
This is amended, Lordship. And the earlier one is there with a flag.
Okay. So this suggested substantial question of law number 1 and 2.
Lordship.
These are basically question of facts.
What's a non-consideration of clear admission definitely raises substantial question of law. If your honor kindly allow me to show the materials. Kindly, plan starts from paragraph page 11, Lordship. If your honor kindly peruse paragraph 4, internal page 5, regular page 15. I have projected my case under section 25 of Limitation Act in respect of Schedule C, road, Lordship.
Page number?
Page number 15, paragraph 4 of the plan. May I read, Lord?
Page number?
Page number 15, Lordship. Internal page 5 of the plan.
5 of the memo of appeal.
Plan, Lordship. Annexure 1 starts from page 11. And paragraph 4, Lordship will find at page 15.
Yes.
Married, Lordship. The plaintiff predecessor, late Ninga Bossa and his family members have using a path measuring area of 8 feet in breadth and 27 feet approx in length, which is link approach to the public road for ingress and egress from his residence. Said path is situated on the northern side of his plot of land 2 Katha within dog number 274 and beside the southern boundary of the plot of land of late Govinda Bossa. Said part is connected to the private road used by late Govinda Bossa and others, and said private road is connected to the public road. Said path, which is measuring 8 feet in breadth and 27 in length, is more specifically described in the Schedule C below. The Schedule C is the suitland in present suit. The Schedule C path is still exists since the lifetime of aforesaid Ningaram Bossa. said part Schedule C having been in use of Ningaram Bossa in his family members, and after his death having been in use of his son late Jagat Bossa, including present plaintiff, for their ingress and egress continuously since the day of late Ningaram Bossa. After aforesaid family partition, defendant of defendant plot of land measuring 1 Dasha Schedule B falls on southern side of the part Schedule C. Except the part, there is no other part connecting to the land of the plaintiff from the public road. If you are kindly peruse reply of the defendant side against this paragraph 4, your lordship will find at page 32. Paragraph 9 of the written statement. My lordship, that the allegation in paragraph 4 of the plan, there is a part measuring an area 8 feet in breadth and 27 feet in length is not wholly true and correct. It is a fact this part covers an area of 4 feet in breadth and 27 feet in length, and this part was connected in the land of Bogaram Bossa of his exclusive use to the public road. Incidentally, this was also used by Jagat Bossa, and after his death, the plaintiff along with the defendant for entry and exit from the public road. So at least, Your Honor, regarding existence of 4 feet in breadth and 27 in length was admitted. At least, if Your Honor kindly peruse next paragraph 10, here is Your Honor, your lordship will find a clear admission that the allegations in paragraph 5 of the plan, the partition taken place between Bogaram Bossa and Jagat Bossa, and after the death of Jagat Bossa, the plaintiff used said Schedule C to come out and go to their residence from public road since many decades past. At least Schedule C part is concerned, at least 4 feet in breadth and 27 length is of the draft Schedule C part was admitted. If Your Honor kindly peruse the judgment. First, Your Honor, the judgment passed by the learned trial court, Your Honor will find from page 41. Learned trial court deciding the dispute of both the parties framed as many as 8 issues. Lordship will find at page 45 all issues framed by learned trial court. Here, main issue, Lordship, issue number 4 and issue number 5. Issue number 4, whether the plaintiff had acquired the right of user of suit part, and issue number 5, whether the defendant have obstructed the plaintiff's use of suit part. This question. If Your Honor kindly peruse the decision of learned trial court below against that issue, Lordship will find at page 48. Total 3 issues were decided, and the effective part, page number 49, last 6 line. Last 6 line. Start from beside, it had been admitted by the defendant number 1 himself that Schedule C land was over Schedule B land.
No, this is not DW1, PW1.
This is here, neither the learned trial court will consider the clear admission on the made in the written statement, nor the admission made in DW1. If Your Honor kindly peruse entire judgment passed by learned trial court, Lordship will not find that admission made in the written statement. And case was dismissed, holding that the Schedule B land is belonging to defendant. That is why the plaintiff has no right to use the Schedule C part. Lordship knows very well that Section 25 governs the acquisition of easement by prescription. A person can claim easement based on continuous and uninterrupted possession. Lordship. Private land is concerned, I have to show possession 20 years, and government land is concerned, I have to show possession of 30 years, as per principle of Section 25 of Limitation Act. That was not considered by both learned trial court as well as first appellate court. Then, if Your Honor kindly peruse the judgment of first appellate court, judgment starts from page number 54. Here, Lordship knows very well that the duty of the first appellate court under order 41, rule 31. Learned first appellate court did not decided any issue, just a point of determination was framed, and on that point of determination, case was decided without deciding any issues framed by learned trial court. That is why, Lordship, I have proposed the issue number 1, non-consideration that clear admission on the part of defendant. Second issue, non-consideration of basic principle under section 25 of Limitation Act. And thirdly, Your Honor, the mandate under order 41, rule 31. The
No,
first
there is
appellate
point
court-
for determination in the page number 61.
Lordship, I want to place judgment of our High Court in this regard. This is judgment, Lordship, reported 2007, 1 GLP page 766. If your Lordship kindly peruse paragraph 15. So first appellate court is the last court of facts, Lordship. If your Honor, issue was not decided, so how first appellate court will you consider each and every facts, Lordship? So that is why under the principle of an order 14, issue framed, Lordship, to consider all those disputed facts. And if you are kindly peruse the entire decision of learned first appellate court, this first appellate court, this point of determination also did not consider my clear admission on the part of defendant. Made in the written statement I have read out in paragraph 9 and 10 of the written statement.
Whether any issue was framed by the trial court on that point?
Yes, Lordship, issue number 4 and 5. So I projected my case under section 25 of limitation. So there
Under
are
section?
several judgment of our High Court also. That's under section 25, a party can seek easement. That's because your Lordship knows very well, easement is not applicable in Assam. So for Assam, so there is no alternative except section 25 of the Limitation Act. The clear admission is not there in both the judgment passed by learned first appellate court and trial court.
So you see, this suggests that substantial question number 1 and 2 both are on facts.
What's it? Section on
So
consideration.
on facts, this court is not entitled to admit your appeal.
What's it?
It should be only
Non-consideration
on
of clear
substantial question
admission.
of law, not only mere question of law. There must be substance in the question.
What's it? Here, records are there, Lordship. The learned, both first appellate court and learned trial court below did not consider clear admission. At least that was the duty, Lordship. If defendants had at least admit that yes, there is a path on 4 feet breadth and 27 feet length. So my allegation was that part was 8 feet in breadth and 27 feet in length. At least learned trial court and first appellate court also have been considered that part of admission, Lordship. That is not there. So non-consideration of facts, non-consideration of admission definitely raises substantial question of law, Lordship. And the usual Lordship kindly tells the principle of section 25 of Limitation Act, that was also not considered by both first appellate court and learned trial court.
You show me the decision where it is stated that a substantial question of No, second appeal can be admitted on the question of facts also.
No, not fact, Lordship. But a non-consideration of clear admission.
Okay, that is a question of fact.
And second point is, Your Honor, non-consideration of entire principle under section 25 of Limitation Act. And thirdly, Your Honor, non-consideration of the mandate under 41 Rule 23. Lordship, kindly carry the judgment of first appellate court. No issue was discussed.
Though several points were not formulated, the court has formulated one question for determination.
If Your Honor kindly carry that admission was not considered by both court below. If it is my main point, main ground will not consider, so how? can
You
the court
Patel,
get access?
what is the decision? We will see, we will examine the matter. Heard, Mr.
R. Ali Lord.
Learned counsel for the appellant, leaves the matter on, okay?
On that too, Lordship, if possible, I will show judgment some.
When?
No, at 2 p.m.
not-
Non-consideration
not
admission
today.
also raises substantial question.
Not today,
On 25th,
short date.
2020.
For further hearing on the point of substantial question of law.
Item 26.
Reversal, it is against the reversal filing money. It is against the reversal filing. It's a money suit. Suit was dismissed. Appeal was allowed.
Egg minute. Item number क्या बना? 26.
Timing of the next item.
After some time?
Wednesday, money.
No, today. After some time.
Who, my lord? Who? That who?
After some time. Item 15, matter for orders.
You have any difficult? No.
Lord, in this case, what is happened, my lord, 30 days delay, my lord. It was filed of in the year 2014, second appeal, my lord. During the pendency of the case, my lord, sole respondent expired with which step, my lord, that has been delay has been condoned, my lord. Subsequently, my lord, it was, my lord, this IA has been disposed of on 17/5/23. Kindly peruse your lordship, 17/5/23. Subject to payment of rupees 5,000. Accordingly, we deposited there 5,000. But it has to be deposited, it has to be disposed of specifically, but as it was not disposed of, thereafter another order comes out, my lord, to take step, my lord, by impeding the legal heirs of the sole respondent. We have taken steps here in, my lord, but the return order is there, my lord. There is a report of the registry. So, my lord, already this 30 days delay, as it is a pending case of the year 2014, my lord, and there is another order, my lord, passed on, my lord. It was on 26/6/24 itself. There is order to substitute the surviving legal heirs of the sole respondent. But in this case, how can I, my lord, take steps, my lord? Because in the second appeal, it cannot be it is not numbered, my lord. Because, my lord, I not specifically dispose of office register, my lord, registry office has apprised me that first time you have to take step in the IA itself. I have taken steps, but earlier there one PP dash was there, my lord, learned advocate, my lord. These are confusing steps. You got 17,523 order kindly be resolved. Subject to payment of rupees 5,000. We deposited it accordingly on my lord 18,523. This dispute between my lord brother and sister, my lord. I'm sister of the respondent, my lord. He has expired thereafter legal years. So your lordship may please to dispose of the IM miscase, my lord. Thereafter and to register the number RSA, my lord. Thereafter we will again take steps, my lord. In this case also I can take able to take. But now
On
I have
the
taken.
previous day, that is 16/9/2024, you have appeared before the court.
Yes, my lord, I appeared. But court, my lord, passed this order. Honorable court passed this order, my lord.
Without hearing you.
No, I was here, my lord, but due to some, my lord,
What due to?
lordship, due to
The
some
order was dictated in the open court.
open court, my lord.
Then
My lord, it is correct, my lord, but that order, earlier order is 17.5 order is there, but possibly it is overlooked, my lord. Well, I have already deposited, and there is another order 26, my lord, 2024 also. Honorable court directed to take steps for the in the RSA, but RSA, how can I take steps? Office cannot be able to accept my steps, my lord, because there was not number.
when the delay was condoned,
Delay was condoned, my lord, this case 17.523. But there is no order subsequently after deposition of my said amount, my lord. 18,523 we deposited.
but there is no mention about condonation of delay. In the order dated 17/5/23.
Yes, my lord. So the delay condoned subject to payment of rupees 5,000 this way.
Where?
In the miscase, my lord, possibly 1921 miscase.
Order dated 17/5/23.
Yes, my lord.
Where it is mentioned.
Subject to payment of rupees 5,000.
Where?
I'm
ज्यादा order वैसे।
उल्टा कुछ लिखा है। Miscase stands disposed of accordingly. Miscase was filed.
But
for the result delay.
where is the order
Oh,
for
yes, my lord,
condoning delay?
that term is not mentioned.
Then?
It's correct. Payment, my lord, Mr. Das is directed to deposit the cost of 5,000 in the registry of the court, and thereafter the same shall be collected therefrom. Miscase stands disposed of accordingly. এই তাৰপিছত এটা আছে 5,000 পদ জমা দিয়া বুলি আছে। Other IAS. Kobita. Billing IAS is that also.
The next matter, full court allowed. Okay, you examine the matter, we'll take it up after some time.
Yes, my lord.
Another.
Or can I can take steps, my lord.
No.
That's the also.
No.
So item 36.
Yes, my lord.
We'll pass the order today.
Yes, my lord.
Lord, this is against the reversal, my lord.
Hmm.
It's a money suit.
Hmm.
Suit was dismissed. Appeal was allowed, my lord.
Hmm.
Case 6, my lord.
Yes.
Substantial question of my lord. Number 1 is whether the exhibit 1, that is a stamp paper, promissory note as defined under section 226 of the Stamp Act, not been marked, sealed, or endorsed by any agency or person duly authorized by the state government has any relevancy towards the proof of its contents and admissibility in evidence. Second is, my lord, whether the exhibit 1 being an instrument without having any date of execution and expression of specified future date for making payment or promise of repayment on demand is legally enforceable promissory note. And third is, my lord, whether in absence of any time period being not the essence of the exhibit 1, the first appellate court committed perversity in not appreciating that suit fail for the want of cause of action. In this connection, my lord, I would like to take your lordship to page 18, my lord. That is the first trial court or my lord. My lord, this is a case of the plaintiff is that they have given a loan amounting to 3 lakhs to both the husband and wife. It has been stated, and the case of the defendant is, my lord, they have never given any money, my lord. Page 20, para 8. However, it is stated that the defendants borrow certain amount of the year in the 2009 from the plaintiff and repaid the same amount. But at the time of taking the loan in the 2009, the defendants were illiterate, signed blank papers to comply with the request of the plaintiff, but the plaintiff filed the document signed in the year 2009 and filed a present suit, alleging that it borrowed a sum of rupees 1,50,000 from the plaintiff and executed a promissory note on 30/8/2014. That was the date of the execution, my lord. On this, my lord, 5 issues have been framed, and my lord, I'll like to take your lordship straight to page 22, my lord. Where issue number 1 and 2 have been taken up together, my lord. Para 17, my lord. Page 22. That the plaintiff Sangeeta Setri, while adducing evidence of PW1 in order to prove the transaction, whether the plaintiff had lent rupees 1,20,000 to the defendant, has exhibited a promissory note of exhibit 1. During the cross examination, a suggestion was put whether there is no time fixed within which amount was to be returned in exhibit 1. Therefore, no cause of action arise for filing at the case. My lord, then, my lord, page 24, para 22, my lord. finding of the trial court, my lord. The absence of the date of execution of the instrument further leads to the absence of further urging a cause of action. On failure of repayment of the amount promised within a reasonable time, as the reasonable time cannot be ascertained. To sum up an instrument without any time mentioned for the repayment and without any date mentioned, which it was executed, does not give a rise to cause of action, my lord. Then, my lord, para 26 to 27 is very important, my lord. Page 26, my lord. However, such facts do not prove the lending amount of recovery. Coming to the cross-examination, witness PW1 stated they could not say if the exhibit 1 contains that the money will be written 1 month, but the defendant has promised to return within 1 month verbally. Pleadings, my lord, no specific dates in the plain itself when it was to be written. There was no corroborating evidence which stated the defendant promised verbally. Also, when a document was executed with a regard to lending of the money, there should be no reason for verbal promise to return the amount. She further said that she could not say that if her husband Gyan Bahadur Setri had put his signature on Exhibit 1 as an executor. PW1 also denied the defendant's suggestion that Exhibit 1 is a force, since it was not stamped and signed by the treasury officer and the stamp vendor, and the date of issuance is also blank. My lord, in this context, my lord, the stamp paper has clearly stated which when the stamp paper can be taken as an admissible in evidence, my lord.
Indian standard.
Section 226 stamp says it should be endorsed. And section 45, my lord, 2 says when can be admissible in evidence, my lord. Stamp Act.
Stamp Act or Indian Stamp Act?
This is my lord. Section 226 first, my lord.
No, there's a
Awesome. এখন ইন্ডিয়ানে হয় ইন্ডিয়ানে 220 section 226 months subsection 26 months. Stamps means any marks, seal or endorsement by any agency or person duly authorized by the state government. It includes an adhesive or impress stamp for the purpose of duly searchable under this act. And my lord, section 42, my lord. Forty-two, 2, my lord.
yes.
Every instrument so endorsed shall thereupon be admissible in evidence and may be registered and acted upon and authenticated if it has been duly stamped. In my case, my lord, the stamp paper where it has been marked as Exhibit 1, it is neither by endorsed, marked or sealed by the proper agency. That question has been put forward in the cross-examination and it is an admitted fact. It has been known. Whether it now, madam, substantial question will arise whether in the absence of any, my lord, page Page 6, my lord, whether the Exhibit 1 promissory as defined under section 226 of the Stamp Act not been merged, sealed or endorsed by any agency or person duly authorized by the state government has any relevancy towards proof of its contents and admissible in evidence. It's a clear violation of the section 42(2), my lord, when it can be taken as an evidence. Section 42(2), my lord. whether it can give a legal effect, my lord, that promissory note.
So that promissory note was prepared on a stamp paper,
Yes,
and that stamp paper lacks Ambrose.
yes. And the contents has been saying it will be paid at a future date at our convenience. My lord, like when it will be paid, nothing has been written contents of that exhibit one. And in the pleadings
Is
of the
it-
plate
is it-
also, my lord, they have failed to
Uh,
show for the want of the cause of action.
Is that document available in this appeal?
My lord, it is not available in the appeal, but I have got my lord with me. For your convenience, my lord. If the records call for, if it is admitted. Your lordship, go through the backside also, nothing has been there. And straightway in the finding of the trial court also, my lord, it has been
Okay, we'll see and pass the order.
my lord, the other, there is also other substantial question of law, my lord. If your lordship Paris, everything, my lord, cause of action also is also there, my lord. Whether there is any cause of action for the suit to arose, my lord. That is also very relevant. So, trial court order is very clear, my lord. And the first appellate court, and in a very harsh manner, without coming into the facts and the evidence before the trial court.
We'll resume after 5 minutes.
Please note dated 6/5/2024, my lord. States in respect of 6, 8, 9, and 16 and 17, my lord. It's already.
So 8 and 9 already died.
Yes,
So you have to take a step.
I have to make the respondent. Their
Legal heirs of their-
Legal heirs, my lord. Yes, my lord.
So there is already a direction. 10/5/2024 to take a step as per office note dated 6/5/2024. You take a step.
Regarding service of the notice in respect of 6, 8 and 9, my lord.
In respect of this office note.
Yes.
You have not gone through the order dated 10/5/24. You go through it better.
Next week, my lord.
No, not next week. You go through it.
Item 15.
In IA 57, my lord. That order was passed, my lord, 26/6. Therefore, my lord, 16/9/24 order is rightly passed, my lord. So that 16/9/24 order is rightly passed, my lord. Because, my lord, after this order, my lord, because I have taken steps in the IA, again I have to send notice. But earlier advocate was there, my learned advocate was there, PP Das. So at this stage, my lord, your lordship may allow me to take Rasti.
or your lordship may also dispose of IA because it is pending from the year 2014 itself. Execution case already, my lord, report has been submitted, my lord. Partition case was there, my lord. Report, my lord, it cannot be partition.
No, this IA has not been disposed of.
This IA has not been disposed of, 30 days delay. Main case 1920, 21, 14.
You could dispose.
1921.
So this IA is disposed of as per order dated 26/6/24.
Yes, my lord.
Then
Then well, not that order in kindly tell your lordship, IA miscase, my lord, 1921/14. Miscase 19, there is the order passed
dated
16/9/24. Again, I have taken steps, but and also sent notice. But the office note shows that, my lord, office note 6/11/24 shows that, my lord, insufficient address. But in their address, we have taken steps. Learned advocate was also there, other side. So, your lordship may please to allow me to take the dusty also steps, or may dispose of also, my lord. In the appeal, I can again take steps, my lord. If it is registered in the RSA.
Mr. Das, I could not follow your submission.
Your lordship may allow me to take dusty service in view of the order that is 16/9/24. Kindly pay your lordship.
Okay. Heard Mr. H. Das, learned counsel for the applicant. Mr. Das submits that he may be allowed time to take step upon respondent number.
Duly implemented substituted respondent, my lord. Solved it.
Namely Onima Thakuria.
Yes, my lord.
Onima Thakuria and Daisy Thakuria Das by registered post with AD as per order dated 16/9/2024. And further, Mr. Das submits that he may be permitted to take permitted to effect service of notice by Dusty mode also. There is accordingly allowed after after effecting service upon respondent newly implemented opposite parties. Mr. Das shall file an affidavit to that effect before this court on next date. List after 2 weeks.
Yes, my lord. I will have to-
In respect of 8 and 9, my lord, I will file the application, my lord, implicating the legal years of the respondent number 8 and 9, my lord.
Mr. Your good name?
S. Islam.
S. Islam, learned counsel for the applicant submits that he may be granted some time to take step upon the respondents as per order dated 10/5/2024. Where is accordingly allowed, step be taken within a period of 1 week from today.
10 days, my lord, otherwise, my lord, I have to take instruction from my client, my
No,
lord.
that's all right.
10 days.
List after 4 weeks.
Item 17. It's about the appraisal of the office note dated 22/10/24. So we have taken the steps by register post as well as through usual process. At the same time, service has been shown to be duly served. So, and upon taking service, it has to be informed that respondent 2 has expired on being taking steps. So we will file appropriate applications by filing the substitution petitions in due course. Usual process has been duly served upon all the respondents.
Heard Mr.
As a Bhakti
learned counsel for the
appellants.
appellant.
Lordship, also on perusal of office note dated 25/10/2024. So LCR of title suit has been received, but LCR of title appeal has not been received yet. So kindly it's a reminder for it. And we take along with the record.
Order dated 23rd/10/2024 indicates that service upon respondent number 1, 3, 4, 5, and 6 completed. And respondent number 2 has expired. The learned counsel for the appellant submits that he may be granted some time to take speak for implementing the legal representative of the respondent number 2. Here is allowed. Recessal is the matter after 4 weeks.
Not so 3 weeks or 4 weeks.
After 3 weeks.
But LCR will be confirmed.
After 3 weeks. Mr. Bhakhtiar further submits that the LCR of trial court has been received.
Trial court has been received, but appellate court has not been received yet.
Appellate court has not been received.
Yes, LCR of title
Trial
appeal
court has already been received as per office note.
dated 25/10/24.
As per office note dated 25/10/2024. Accordingly, it is provided that the rest shall issue reminder to the learned appellate court for transmitting the record without further delay. Lays the matter after 4 weeks.
Item 18.
May I please, your lordship? Your lordship, on the date of the respondent number 2, your lordship, we have filed a substitution, your lordship. But before that, we have to condone delay of 857, your lordship, for setting aside of abatement. So I may be allowed to take step, your lordship, in IA 2836 of 24, your lordship.
Heard Mr. S. Paul, learned counsel for the applicant, and Madam
On behalf of YS Mannan, R Begum.
R. Begum, learned counsel appearing on behalf of Mr. Y. S. Mannan, learned counsel for the respondent number 1.
Respondent number 2 is performer respondent.
This application under section 5 of the Limitation Act 1963 is preferred by the applicant for condonation of delay of 857 days in filing the application for setting aside the abatement of the incident RSA on the date of respondent number 2. Respondent number 2. How many respondents are there?
Your lordship, main respondent 1 and 226, your lordship. Performer. 2, 3, 4, 5, 6.
And Madam, you are appearing for respondent number?
1.
Respondent number 1. Issue notice returnable in 4 weeks as to be taken by registered post with AD and also by usual process. Within a week from today. However, no formal notice is required to be issued to the respondent number 1 since Ms. Begum appears and receive notice. However, extra requisite copy of the petition will be furnished to her during the course of the day. List the matter after 4 weeks.
Okay, sir.
Item 19.
The counsel for respondents was directed by the last order to provide the address of respondent number 4. I got the address today, but along with the information that respondent number 4 has expired
3 years ago.
3 years back. That information has only come today. They may give us the names of the legal heirs of, if any, of respondent number 4. But I may take necessary steps.
Respondent number
4.
Heard, Mr.
A. Ganguly.
A. Ganguly, learned counsel for the appellant, and Madam
S. Shahid.
S.
Shahid.
Learned counsel for the respondent number. You are for respondent number
All except 4.
for the respondent number 1, 2, 3, 5, 6, and 7. 6 and 7. The learned counsel for the appellant submits that, as per his information, respondent number 4 suffered demise about 3 years back. Who will furnish the information to you?
But they have to, because the other appellants are all the brothers and sisters only. The other appellants whom they are representing, they are the own brothers and sisters. Respondent number 4, sister of the other appellant. Own sister.
The learned counsel for the appellant submits that the counsel for the respondents may be directed to furnish to him the particulars of respondent number 4 so as to take necessary step for implementing the legal representative of respondent number 4. Prayer is accordingly allowed. The learned counsel for the respondents are directed to furnish particulars of respondent number 4 to the learned counsel for the appellant within a week from today. List after 3 weeks. Next.
Item 20.
Actually, in this case, service is complete and LC has been received option. So matter of fixed for hearing option.
LC received.
Lordship, here, Lordship, some confusion arose the Lordship. Actually, I am for respondent number 1, Lordship, main is respondent of it. But mention has been made by someone else, Lordship. I have not mentioned the case, Lordship. I don't know, Lordship, who is that person, Lordship, who is the advocate, Lordship, I don't know, Lordship. In fact, two answers taken from me, Lordship.
We'll have to check.
Mention it there, some, Mustafa Hussain has mentioned the case. But Okalatama is not there for him, Lordship.
Mentioned by Mustafa R. Ali and M. Hussain.
I may have thought, and Mr. Sir is their Lordship, but they have mentioned, Lordship, his Okalatama is their Lordship, not their Lordship.
276, 2019.
At least on NOC was to be taken, Lordship, and that is also not done, Lordship.
When Mustafa Hussain had mentioned the matter,
No, Mustafa is not, he was not here, Lordship. Actually.
mobile number is here, or no, mobile number is here, you can contact him. Heard, Mr.
R. Sharma.
R. Sharma, learned counsel for the appellant, and Mr.
Yes, of Lordship.
S. Hawk, learned counsel for the respondent number
1.
1, and Mr.
Immover.
A. Mubarak, learned counsel for the respondent number 2.
2 and 3.
2 and 3. The learned counsel for the appellant service submits that in this appeal, service already completed and LCR has already been received, and as such the matter may be listed for hearing. Accordingly, it is provided that SSL lists the matter for hearing in usual course.
Online, Lordship.
21.
May I please, Lordship?
I am for appear on behalf of appellant. Respondent number 2 file wakalat nama, but it is not take with a case performer respondent. And for respondent number 1, we took the step on today itself. Service of notice may be awaited.
You have taken a step today only.
Yes, sir.
Heard, Mr.
M. Thakuria for S. Sharma,
N. Thakuria, learned counsel for the
appellant.
appellant. S. J. Sharma.
Yes, sir.
S. J. Sharma. Appearing on behalf of Mr. S. J. Sharma, learned counsel for the appellant. The learned counsel for the appellant submits that he has taken a step upon respondent number 1 only today. So list the matter after 4 weeks, awaiting service report upon the respondent number 1. The learned counsel for the appellant further submits that when counsel has filed his Wakalatnama on behalf of respondent number 2, but the same has not been taken to it, the record. Rest shall do the needful in this regard.
22.
May it pleases your lordship. Lordship, in this case, respondent number 1 have entered the appearance and 2 and 3 have filed their affidavit. Lordship, the matter may be fixed for hearing, your lordship. LCR has been received.
Both the parties are duly represented by their engaged counsel. It is submitted at the bar that service completed and the LCR has also been received and the matter is ready for hearing. Accordingly, it is provided that justice shall leave the matter for hearing after
Your lordship, please.
in usual course. Okay.
23.
May it please your lordship.
Hmm.
Lordship, notice upon the respondents have been served. And lordship, it seems like none has appeared for respondent number 2 yet. Also, respondent number 1 was about to file objection in the IA, but till now we haven't received any copy of that.
There is only one respondent.
There are 2 respondents.
What are the names?
Lordship, one is Dilip Chandra Borua and one is Jayanta Prasad Sharma. One has been served and
You come to this in this IA, you come to page number 4.
yes, lordship.
How many respondents are there?
Okay, there is one respondent.
1.
Yes, lordship. But in the RFA, there are 2 respondents.
Heard, Mr.
He does.
Learned counsel for the applicant in IA number 136, 2023. None appears for the respondent on call. List the matter after 2 weeks.
Lordship, interim may be continued.
Till returnable date. No, till next date. Interim order pass release will continue.
24 and 25. What LCR has received? The matter may-
Ready for hearing?
Yes.
Both the parties are represented by their engaged counsel. It is submitted at the bar that the matter is ready for hearing and the LCR has also been received. And accordingly, it is provided that Resi shall list the matter for hearing in usual course. Resi will fix the date.
Malam, my one prayer, Malam, my learned friend may be directed to provide a copy of the Malam RSA, Malam, item number 24.
You furnish a copy to him. Is it necessary to pass any order to that effect? Not necessary.
He may undertake, I have nothing to.
I'll-
How like that?
26.
Okay, please, I'm on behalf of the appellants, Your Honor, by office note dated 2024, notice issued to the concerned party to place.
You are for respondent number one.
One, my lord.
Heard Mr.
R Bhagavati,
R. Bhagavati, learned counsel appearing on behalf of Mr.
OP Bhatti.
O.P. Patil, learned counsel for the appellant. And also heard Mr. Dotto, learned counsel for the respondent number one. Office note dated 2/11/2024 indicates that notice issued to the notice was issued to the respondent number 2 and 4. But no report has been received. List the matter after 2 weeks, awaiting service report upon respondent number 2 to 4.
27.
Obliged. Respondent number 4 has not been served, my lord, your lordship.
You are for respondent number
Wait, 1 to 3.
1 to
We have
3
filed affidavits today, madam. We have filed affidavits today.
today. None appears for the appellant on call. However, Mr. G. N. Chawla, learned senior counsel, assisted by Ms. Bhattacharya, learned counsel for the respondent number 1 to 3 present. Mr. Sahewala submits that he has filed. No, respondent number 1 to 3 had filed the affidavit.
Both the cases.
Filed the affidavit today. List the matter after
Service on the,
2 weeks.
the service of the respondent number 4.
But the other side is absent, whether they will take any step. Office note dated 7/11/2024 indicates that neither ID card nor unserved notice in respect of respondent number 4 has been received. So SSL list the matter after receiving service report upon respondent number 4.
28 and 29.
Your Lordship, as per office note dated 4/11/24, service has been completed and LCR has also been received, Lordship. May I please, Your Lordship, there is a IA against the RSA 151. The IA number is 2420. We want to file a affidavit. Please,
I is for staying.
sir, order 41 rule 27. The main RSA 151, I is 2420.
Okay, I you take down.
For
Heard
which-
Miss
B. Hajarika on behalf of.
B. Hazarika, learned counsel appearing on behalf of Miss R. Chaudhary, learned counsel for the applicant, and Madam
P. Bordulai.
P.
For
Bardoli,
P. Bhattacharya. Panchali Bhattacharya.
learned counsel appearing on behalf of Miss P. Bhattacharya, learned counsel for the respondent. Miss Bordoli submits that she may be granted some time to file objection in this I.
4 weeks.
Where is accordingly allowed, SSL is the matter after 4 weeks. LCR has been received in the main.
Yes, Lordship, LC has been received.
Heard Ms. So-and-so, learned counsel for the appellant, and Madam so-and-so, learned counsel appearing on behalf of Ms. P. Bhattacharya, learned counsel for the respondent. Is submitted at the bar that service already completed and LCR has been received and the matter may be listed for hearing. Accordingly, it is provided that SSL list the matter in usual course for hearing.
28 or 29. I do 29.
Same,
So we listed in order column. Lordship.
okay.
Item 30.
Respondent number 1 appeared by filing Wakalatnama and office note 2910 says, my lord, the 2, 3 and 4, my lord,
Mm.
is a service complete.
Mm.
My Lanet file for respondent number one.
For respondent number one, my lord.
Then 2, 3, and 4, my lord, office note says service complete. So, my lord, and LCR also
Received.
received, my lord. The all the appeal is, my lord, service is complete, my lord. May take for hearing, my lord.
Heard Mr. C. Goswami, learned counsel for the appellant, and Mr.
B. Borgohain. B. Borgohain. For
P.
respondent number
Borgohain, learned counsel for the respondent number.
one.
Respondent number 1. Office note dated 29/10/2024 indicates that service upon respondent number 2, 3, and 4 completed. But they remain unrepresented today. Mr. Goswami, learned counsel for the appellant, submits that since service has already been completed and the LCR has also been received, the matter may be listed for hearing. Accordingly, it is provided that recessal is the matter for hearing in usual course.
And the stay, my lord. Stay may continue, my lord, that earlier interim stay in IA, my lord. Or
Yes,
since appeal admitted, my lord, in second appeal, my lord.
My lord, I am disposed.
any objection?
Lordship, I think I was disposed, Lordship.
No, not disposal. Only state till returnable date, till today.
Lordship.
Any objection?
No, Lordship.
No objection. Heard Mr. Goswami, learned counsel for the applicant, and also heard Mr. Borgohain, learned counsel for the respondent number 1.
I may be pending, Lordship. We have filed objection, Lordship, in the meantime, Lordship.
Appeal is admitted, my lord, submitted.
Office note dated 29/10/24 indicates that service upon respondent number 2 to 4 completed and none appears for the for them on call. The learned counsel for the respondent number 1 submits that he may be granted some time to file objection in this application. Fair is accordingly allowed, less the matter after 2 weeks.
Is it 4 weeks?
Okay, till then interim order pass
No, my
order
lord,
shall continue.
Continue.
I copy was not received. Only I copy have been received.
It furnished good.
Yes.
It will যাব okay, I to list for
32.
Here, my lord, IA has been filed by the appellant, my lord. We want some time for filing objection, my lord. 2 weeks time. my lord.
Heard Mr.
M. Kashyap, your lordship.
M. Kashyap, learned counsel for the applicant. And also heard Mr. N. Hawk, learned counsel for the respondent.
Opposite.
This application under section 39 rule 1 and 2, read with section 151 of the Code of Civil Procedure, is preferred by the applicant for granting temporary injunction. Mr. Hawk, learned counsel for the respondent opposite party, submits that he may be granted some time to file objection. Here is allowed recessal is the matter after 1 week,
After 2 weeks.
after 2 weeks.
Problems.
Item 37.
May please, your lordship. Scan copy was called for, I think, office not received, maybe fixed on 18 million.
Heard Mr. C. Borough, learned counsel for the petitioner.
My lord.
Office note dated 1/11/24 indicates that a scanned copy of the LCR has not been received from the Court of Learned
Munshi.
Civil Judge, Junior Division number 4.
My lord.
Accordingly, it is provided that recessal lists the matter on
18 million
18
of 11.
18/11/2024 and issue reminder to the learned trial court for transmitting the scanned copy of the record without further delay.
Highly obliged.
Item 39 for hearing.
May I give your lordship?
Mm.
My senior Mr. R.L. Yadav, Mrs. K. Yadav is out of India. So this matter may kindly be attended. I have already tried the other side, but I have not contacted. So this matter may kindly be listed after 10th December, and they will come around at 7th December. So this matter may kindly be fixed after 10th. And leave of absence is also there.
No, madam, this matter was mentioned by the other side.
Yeah, I don't know why they are also absent.
Third, miss, your good name, please.
M. Bhattacharya.
M. Bhattacharya, learned counsel, appearing on behalf of Mr. R.L. Jadhav, learned counsel for the appellate. None appears for the respondent on call. Ms. Bhattacharya submits that Mr. R.L. Jadhav is out of the country and prays for listing the matter after
10th December.
After 10th of December. Pair is accordingly allowed. Recess and list the matter after 10th of December.
Timing item 3.
Other side has made a request to take for adjournment, my lord. And so
Who is for other side?
Mr. H. Chaudhary, my lord.
Pardon?
H. Chaudhary. H.R. Chaudhary, my lord. Private respondent.
Heard, Mr. Your good name?
B. Purkasto.
P. Purkasto, learned counsel for the petitioner. None appears for the respondent on call. List the matter on
27.
27. Okay.